Guerra then says he has to check to see when Mariel Sullivan got her law license. I want to show you a signed affirmation, 4 pages long, dated November 28th, 2000. This signed affirmation under perjury is signed by my attorney, Judge Ronald Aiello, a former criminal judge in Brooklyn. Jeannie McIntosh of the New York Post called Judge Aiello up, and Judge Aiello stands by what he signed. I'd like to read this now. Ronald Aiello hereby affirms the following under penalties of perjury. I am an attorney admitted to practice before this court, and I am appearing on behalf of the petitioner of counsel herein. The petitioner herein had informed me that he believes that he was denied his rights to a line of duty disability pension as a result of illegal fraudulent activity perpetrated upon him by the New York City Fire Department and the 1B Pension Board. In particular, it is petitioner's contention that 2 individuals, actually there was 3, but 2 individuals, Mariel Sullivan and Marlene Gold, who were at the time in charge of supervising documents, medical reports, and determinations of pension awards, were guilty of certifying medical reports and withholding medical reports and documents of which petitioner had signed receipts for, and which would have resulted in the petitioner being awarded a line of duty pension as opposed to an ordinary that I'm retired on now. It is also petitioner's contention that Mariel Sullivan had been writing, in quote, drafting, in quotes, petitioner's very own 1B medical board certificates. This is due to the fact that the first, second, and third 1B board had no medical evidence of any kind to come to the decisions as written on such 1B medical certificates. Also, petitioner has evidence that shows Mariel Sullivan was writing, drafting medical certificates in letters written by Fire Department Deputy Commissioner Clinton of the Fire Department Board of Trustees. The Supreme Court's written decision in Petitioner's Article 78, dated September 22, 1993, by Honorable Judge Vaccaro, which in part states, the court finds that there is an absence in the medical records of any support for the medical board's position as set forth in the first 3 reports. That the petitioner was disabled, that his petitioner's disability was caused by 1983 or 1987 non-service related incidences, since in no report of these incidences is there any mention of neck or back pain. The court finds their determination to be arbitrary and capricious. That the result of respondents' activities, relevant records were deleted and omitted from the file submitted to the courts in connection with petitioner's underlying Article 7 proceedings. I guess it should be Article 78 proceedings. Upon being informed of these facts, petitioner's attorney, Gary Barinholtz, Esquire, and I, meaning Judge Aiello, had contacted the Kings County District Attorney's Office and met with Charles Guerra, Assistant District Attorney in charge of the Rackets Bureau. At a meeting with the petitioner and Mr. Guerra, these facts together with numerous documents were presented to Mr. Guerra for review. Mr. Guerra opened an investigation and proceeded to gather information and researched various legal aspects of petitioner's claim, which took place over a period of approximately 16 months. Upon recent completion of Mr. Guerra's inquiry and investigation, and after a number of meetings, he met with petitioner, Mr. Barinholtz, and me. Mr. Guerra stated that he believed that there was wrongdoing in connection with the handling of petitioner's pension application, meaning mine, thereby depriving petitioner of his line of duty disability, and that voluminous documents were in fact missing from petitioner's file.